Welcome back. As you know, my name is Brian Burkhoff, and this is the New Jersey Workers' Compensation Conversation. Today, we'll be talking about Medicare and how it may be impacting the claims that you are working on. As you may or may not know, in all New Jersey workers' compensation claims, the respondent has to consider Medicare's interest, while the petitioner considers Medicaid's interest. So, when we're talking about Medicare, we should know that it's administered by the Center for Medicare Services, which we refer to as CMS. We're what's considered the primary payer, and Medicare is a secondary payer. So in all cases where the petitioner should be receiving authorized medical care through workers' compensation insurance, we have to ensure that Medicare is not footing the bill. So how do we know if an individual actually is on Medicare? The first is easy enough. We look at their age. Anyone who's 65 or older is age eligible for benefits, even though they may not always be receiving them. The second way is if they are younger, but they have a disability and they're receiving Social Security disability. In all cases that I handle, I am sure to reach out to the petitioner's attorney, regardless of the petitioner's age, to confirm whether or not Medicare may become an issue later in the case. So, when we're talking about Medicare generally, when we're looking to resolve a claim, there's two potential things that we need to be looking for. The first is a conditional payment lien, or CPL, and the second is a Medicare set-aside, or MSA. A CPL, in my mind, we're looking backwards. We're saying, did at any point during the duration of the workers' compensation claim, did Medicare pay for treatment that should have been paid for under workers' comp? So what we do is obtain a lien letter to say whether or not there's any lien being asserted by Medicare. An example of this would be right after the claim happens, right after the accident happens, petitioner goes to the hospital. There hasn't been a workers' comp claim set up yet, and they just provide their Medicare information and it's charged through that. Because it was related to a workers' compensation injury, we'll have to make sure those bills are paid by the workers' comp insurance at the end of the case. We can dispute liens if they are seemingly not related to the claim, and sometimes we'll get it pushed to zero and settle the case to say we don't owe Medicare any money, but we need to represent that their interests have been taken into account. For Medicare set-asides, we're looking into the future. So we're saying petitioner is going to have their case closed out on a full and final Section 20, and we will have to make sure the petitioner is not going to seek Medicare to pay for any treatment that may move going forward. So in situations where petitioner is 70 years old and we're trying to Section 20 a case, we have to determine whether an MSA is necessary. However, a major change just happened earlier this month on April 4th to the requirements for MSA. Previously, it was practiced that we only obtained an MSA for Section 20 over a $25,000 threshold. However, now we must report all cases in where petitioner gets a settlement and is on Medicare that exceed only $750. So obviously, the threshold has been dropped substantially, and almost all cases where we're resolving by way of Section 20 will need an MSA. It's optional to submit for CMS approval prior to the settlement, as always, but we highly recommend that you obtain a vendor or an in-house Medicare specialist to protect yourself when resolving claims by way of Section 20 when petitioner is a Medicare recipient. Now, the threshold being dropped from $25,000 to $750 is obviously going to require that a lot more cases get Medicare set-asides, and that's going to slow down the settlement process. However, there is a positive. Coming soon, in July of this year, there is another new standard that's going to be applied. So specifically on July 17th, CMS is no longer going to accept submissions for $0 MSAs. So we will not need to get approval before moving forward with these types of settlements. There are going to actually be 4 types of categories that our case will need to fall under in order for us to resolve by way of a 0 MSA without any submission. Those 4 categories are: first, if the treating doctor documents that the petitioner will no longer need any additional care related to the workers' compensation injury. The second is if it's a denied claim and we have not paid any benefits whatsoever to petitioner by way of medical. Third is if there has been a determination on the merits by the court that we are not necessarily required to pay any medical for petitioner. Example of this being the case is determined that petitioner's injury is not causally related to work and it's a pre-existing condition. And the fourth category, which is being recently added, is that if the claim was denied but pending investigation pursuant to Section 15, where we ultimately continued to deny the claim. Any medical paid during that period of investigation can still be considered as a non-related medical expense should we later determine that the payments were unrelated. So, if we can find that the petitioner's situation falls into one of those 4 categories, we should be able to fairly quickly resolve the case by way of a 0 MSA. Well, how do we ensure that our specific facts under our specific case falls into one of those categories? We have to make sure that we're utilizing Medicare vendors and specialists to get their confirmation that we have properly considered everything under those 4 categories and for Medicare's interest. So what we'll want to do is have strong documentation in our files. We want to show that we reached out to a vendor, that we have a ledger showing that no payments were made to petitioner if that's the case. Alternatively, we would have a doctor's note from the treating physician to say petitioner is never going to need additional care with respect to this body part. So in short, we just want to make sure that we have crossed our T's and dotted our I's. We need documentation should Medicare come back and say, you allocated $0 for future treatment and we disagree. How did you come to that conclusion? How did you properly ensure our interests were taken into account? We want to be able to say, here's our file. This is the vendor's determination. Here's our supporting documentation. That's how the conclusion was reached, that a 0 MSA was appropriate. These are obviously big changes to Medicare, and I'm sure they're going to continually progress as we move forward. So we wanted to make sure that you became aware of the changes and are applying them immediately to all the cases that you're dealing with. If you have any questions about how this impacts your claims, feel free to reach out to me. I'm happy to discuss your question individually or on an upcoming video. And with that, I hope you have enjoyed our compensation conversation, and I look forward to speaking again soon.